You're sitting in a courtroom in Philadelphia. It's April 2024. Three men, Edward Haynes, Leon Johnson, and William Ochoa, are about to hear the words that will free them from prison. They've spent 28 years behind bars. 28 years. All three were convicted of murder. All three were innocent. And all three are walking out because of one thing: DNA technology that proves what forensic experts got catastrophically wrong in 1996. This is the story of how science meant to convict the guilty has destroyed the lives of the innocent. And it's happening more often than you think. Forensic science sounds objective. Crime lab. Evidence, microscopes, DNA sequencing. It sounds like mathematics, like something that can't be bent or twisted by human bias. But here's what juries don't always understand. Forensic science is still science conducted by humans. And humans make mistakes. They see what they expect to see. They become wedded to a theory. They stop looking for evidence that contradicts their conclusion. In 2026, we know this. The Innocence Project, the National Academy of Sciences, even the FBI itself, they've all admitted that certain forensic techniques are unreliable. Some should never have been used at all, yet innocent people are still in prison because of them. Let's go back to Philadelphia, 1996. The victim is Helen Device, killed during a robbery. The crime is brutal. The neighborhood is shocked. Police have pressure to make an arrest, serious pressure. Detectives bring in three men, Edward Haynes, Leon Johnson, and William Ochoa. None of them had criminal histories, none of them had obvious motives. But forensic evidence supposedly ties them to the crime. That's what the jury hears. That's what convicts them. The evidence: serology, blood typing, and hair analysis. Both techniques that we now know are far less reliable than they were presented to be. Prosecutors told the jury these tests were virtually certain. They weren't. Not even close. 28 years pass. Haynes, Johnson, and Ochoa sit in prison, and then DNA technology finally reaches a level where it can definitively answer the question, whose DNA is on the murder weapon? The answer: not theirs. The DNA belongs to someone else entirely. Someone who was never charged. Someone who should have been the suspect from the beginning. The Innocence Project fights for their release. And on April 9, 2024, after nearly 3 decades, the three men walk free. But here's the haunting part. If forensic science had been properly understood back in 1996, they might never have gone to prison at all. Now let's talk about bite mark analysis. This one is particularly disturbing because it's based on a seductive idea. That teeth are unique, like fingerprints, and that bite marks can definitively identify a perpetrator. Sounds reasonable, right? It's not. In 2024, the American Dental Association finally admitted what critics have been saying for decades. Bite mark analysis is not a reliable forensic tool. It's been discredited. Yet how many people are still in prison based partly on bite mark evidence? How many convictions rest on the testimony of an expert who testified with absolute certainty that a defendant's teeth matched a bite mark on a victim's skin? We'll probably never know the exact number, but we know it's significant. There's a reason the phrase junk science exists, and bite marks are Exhibit A. The problem is this: skin is not a stable surface. It moves, it stretches, it heals. A bite mark isn't a precise imprint. It's a bruise, a contusion, something that changes over time. And yet forensic dentists would compare photographs of bite marks to dental molds and testify to the jury that they were certain, absolutely certain, that this defendant made that bite. Defense attorneys would challenge them, saying the science wasn't sound. But the experts' confidence was persuasive. Juries believed them, and innocent people went to prison. Fingerprint evidence feels more solid, doesn't it? Fingerprints are like DNA, unique to each person, unchanging throughout life, and fingerprint analysis has been used in courts for over a century. Surely that means it's reliable? Not necessarily. In 2004, the FBI made a shocking admission. Brandon Mayfield, an American attorney in Portland, Oregon, was arrested and detained after his fingerprints were allegedly matched to evidence from the Madrid train bombing that killed over 190 people. The problem? The match was wrong. It was a mistake. Mayfield was innocent. He spent 2 weeks in custody based on a fingerprint match that trained FBI examiners got completely wrong. The case was dismissed, and Mayfield was compensated, but not before his life was turned upside down. And Mayfield isn't alone. Researchers have documented numerous cases where fingerprint evidence has been mismatched or misinterpreted. The underlying assumption is that fingerprint comparison is foolproof, that if an expert says two prints match, they must match. But fingerprint analysis is interpretive. An examiner looks at whorls and ridges and tries to determine if they correspond. It's not like comparing two identical computer files. There's judgment involved, and judgment can be wrong. By 2026, fingerprint evidence is still used in courtrooms, but some jurisdictions have become more cautious about allowing testimony that presents fingerprint matches as absolutely certain. The language now, in better courtrooms, is very strong support or highly consistent, not certain identification. Now let's talk about hair analysis. This one kept innocent people in prison for decades before anyone seriously questioned it. Hair comparison under a microscope seems straightforward. Compare the hair found at the crime scene to hair from the suspect, and if they look similar, it's a match, right? Wrong. Hair analysis is so unreliable that the FBI launched an unprecedented review in 2015. The results were staggering. Of 257 cases examined where FBI examiners had provided hair analysis testimony, examiners gave testimony exceeding the limits of hair analysis science in approximately 95% of the cases. 95%. These examiners testified with confidence that hair evidence matched a defendant when the science simply does not support that level of certainty. One of the most shocking cases involves Jerry Miller from Illinois. Miller was convicted of rape in 1981, based partly on hair evidence. He spent 17 years in prison before DNA evidence exonerated him. His hair had been microscopically compared to hair from the crime scene and found to match. The expert testified with confidence. The jury was convinced. But when DNA testing finally became available, it proved Miller was innocent. The hair evidence meant nothing. It was just wrong. And yet, during those 17 years, an actual rapist was walking free, possibly committing more crimes. This is the real cost of faulty forensic science. Not only does it destroy innocent lives, it allows guilty people to evade justice. Then there's arson forensics. For decades, fire investigators would examine a burned building and declare with certainty that the fire was definitely arson. They had their signs: poor patterns, V-shaped burn marks, lack of flashover evidence. The problem? Much of what they believed about fire behavior was wrong. They were taught that certain patterns indicated accelerants, that certain burn patterns proved intentional fires. But when scientists actually studied fire behavior in controlled conditions, they discovered that accidental fires could produce exactly the same patterns. The forensic theory was flawed from the ground up. Yet innocent people went to prison, convicted of arson, convicted of murder when a fire was deemed intentional arson. Some have since been exonerated. Digital forensics is the newer frontier, and we're already seeing problems emerge. A digital forensics expert testifies that data recovered from a hard drive proves the defendant visited child exploitation websites, or that metadata proves the defendant sent a threatening email. But digital evidence is complex. Chain of custody is crucial. Data can be corrupted, overwritten, or misinterpreted. In 2026, we're seeing increasing challenges to digital forensic testimony in courtrooms. Defense experts are questioning how evidence was preserved, how it was analyzed, and whether the conclusions the prosecution is presenting are actually supported by the data. It's a field that needs serious oversight, because we're moving toward a future where digital evidence will dominate trials. If we get it wrong now, we'll have a generation of wrongful convictions based on misunderstood technology. And finally, let's talk about something more nebulous but equally dangerous: forensic psychology and behavioral analysis. The FBI's Behavioral Analysis Unit became famous through television shows. Profilers analyzing crime scenes, building psychological profiles of killers. It sounds scientific, it sounds authoritative, but much of it isn't based on rigorous science. When a profiler testifies that a certain behavioral pattern indicates guilt, or that a certain type of person is likely to commit a certain crime, they're often operating in an area where science gives way to subjective interpretation. Confirmation bias sets in. The profiler sees evidence that confirms their theory and ignores evidence that contradicts it. Juries trust them because they sound confident and they work for prestigious agencies. But the underlying science is shaky. So what's changed by 2026? For one thing, there's much greater skepticism about forensic evidence. The National Academy of Sciences published a landmark report in 2009 questioning the reliability of many forensic disciplines. By 2026, that skepticism has seeped into courtrooms. Judges are more willing to exclude expert testimony that isn't grounded in solid science. Defense attorneys are better at challenging forensic experts, asking them tough questions about the error rates in their discipline, about whether they've been tested to determine if they can actually do what they claim to do. And some forensic techniques, bite mark analysis most prominently, are being phased out. But the work of exoneration continues. The Innocence Project, since its founding in 1992, has helped exonerate over 200 people in the United States, and a significant portion of those cases involved flawed or misused forensic evidence. Just recently, in 2024, we saw those 3 men freed in Philadelphia after 28 years. DNA testing has become more sophisticated, less expensive, and more widely available. Cold cases are being reopened. Evidence that's been sitting in storage for decades is finally being tested. Yet here's the tragedy. For every person who gets exonerated through DNA evidence, there are likely others who can't be tested because the evidence is gone, or the original crime doesn't have biological evidence that can be tested, or the statute of limitations has passed. And there are likely innocent people still in prison who don't have access to DNA testing or who can't convince a court to order it. The Innocence Project estimates that 4 to 6% of criminal convictions may be wrongful. That's a startling number. In a country with over 2 million incarcerated people, that suggests tens of thousands of innocent people are behind bars right now. The real question we have to ask ourselves is this: if science fails us, if the tools we created to find the truth can be misapplied or misunderstood, how do we protect ourselves? The answer is multiple layers of scrutiny. Better training for forensic examiners, mandatory error rate studies, defense attorneys with the resources to hire their own forensic experts, judges who understand the limitations of forensic evidence, and most fundamentally, a legal system that remembers, beyond reasonable doubt. That's the standard. That's what conviction should require. Not confidence, not an expert saying, "in my experience," but evidence that proves guilt beyond a reasonable doubt. So here's my question for you. How confident are you in forensic science after everything you've just heard? And more importantly, how confident should we be as a society? Should juries be allowed to see forensic evidence presented as absolutely conclusive when scientists themselves say it's not? Should we keep putting people in prison based on techniques that have been largely discredited? These aren't abstract legal questions. These are about whether innocent people get to go home to their families or die in prison for crimes they didn't commit. Edward Haynes, Leon Johnson, and William Ochoa got their freedom, but they lost 28 years. What happened to them happened because forensic science failed them, and it's happening to others right now. If you found this investigation into the dark side of forensic evidence shocking, subscribe to The Verdict Room. We dive deep into cases like these every week, cases where the legal system gets it wrong, where science gets twisted, where innocent lives hang in the balance. Comment below. What do you think should be the standard for forensic evidence in court? Should all convictions based solely on forensic testimony be reviewed? Should we have a statute of limitations on DNA exonerations? Let me know your verdict. And share this with someone who cares about justice.